Thank you. Please be seated. Please be seated. Good morning, everyone. We're on the record in Camden County Democratic Committee versus, and my apologies for mispronouncing the names, Druckenbrod et al. L2089-25. Appearances, please.
Your Honor, William M. Tambusi, Brown and Connery for Camden County Democrat Committee in James Beach.
Michael Miles from Brown and Connery, also on behalf of the plaintiffs.
Your Honor, Yael Bromberg of Bromberg Law, on behalf of the defendants, Susan Druckenbrod, David Stahl, and Rena Margulis.
All right. I think the first issue, this is the return date order to show cause. It was filed under 452. I executed the order. That's what brings us all today. But before we go on to the merits, there's two underlying matters. One is the state's 113-9 motion to appear as an amicus. I'll sign the order. There was no objection. Mr. Tambusi did not consent, but he indicated he would not object. If a certain condition was met, that condition was met. So I'll sign the order. There's the issue concerning what I disclosed yesterday. Anybody have an objection or want to discuss it?
No objection, Your Honor.
And none for us.
All right, very good. Mr. Tambusi, you represent the plaintiffs. Let's hear from you first.
Thank you, Your Honor. May it please the Court. Your Honor, the state cannot justify regulating an a party's internal affairs without showing that such regulation is necessary to ensure that the election is...
All right, if you're more comfortable seated, you don't have to stand on my account. It's up to the two of you.
I've been around for such a long time, Judge, I'm just used to standing. Again, Judge, a state cannot justify regulating a political party's internal affairs without showing that such regulation is necessary to ensure an election that is orderly and fair. That's the United States Supreme Court decision in Yu versus San Francisco. There is no dispute whatsoever for purposes of this application before the court that the three progressive candidates received more votes than the other candidates in the election. And while there's certainly issues about how the ballot was structured, as the Attorney General's office acknowledges, and issues with the fact that the Attorney General's office and the Division of Elections did not provide the county clerk with guidance on how to structure the ballot until after the ballot had to be printed. There are no disputes on how the votes were counted in this election, and there's no disputes on how the votes were certified. Those votes were certified. With that context, in a sentence, this case is about the right of the Camden County Democrat Committee, a statutorily sanctioned political association made up of volunteers, to organize itself, conduct its affairs pursuant to its bylaws that it adopted, and to associate with those who will advance the CCDC's interests in the support of Democratic candidates. To the contrary, both the progressives and the Attorney General's office, working in tandem, seek to plunge deep into the business of resolving an intra-party controversy and drag this court into the fray, contrary to the established principle of judicial restraint in this area, and in the absence of a violation of a controlling statute or infringement of a clear legal right. And that, Judge, is Deemer versus Jones, the New Jersey Supreme Court, Philippone versus O'Connor, and Hartman versus Covert. There is no violation of any controlling statute or infringement of any clear amendment right, a clear legal right, in the assertion of the First Amendment rights that the party makes here today. Because the party has the First Amendment right of association. And that's the United States Supreme Court case of New York Board of Elections versus Lopez Torres. The three individuals that received the most votes have been recognized as members of the Camden County Democrat Committee and have been permitted to participate, as is consistent with the CCDC bylaws, in its actions. But what has happened since the vote was certified was that these three individuals sought to take actions contrary to those permitted and authorized by the CCDC bylaws. That is, believing they have the power to do so, the three individuals have met sought to organize, sought to adopt the Constitution and bylaws, and sought to fill the 71 remaining county committee seats from Cherry Hill, even though those 3 individuals do not constitute a quorum to take any such action. This is clearly an intra-party controversy. With the court's indulgence, I'd just like to walk quickly through the statutes that are at issue here. In that, we start with the United States Supreme Court decision in U versus San Francisco, which held that a state statute cannot limit a political party's discretion on how to organize itself, conduct its affairs, and select its leaders. Nor do the rules of statutory construction permit statutes to be construed to limit a political party's discretion in this regard. In that context, the analysis starts not with NJSA 19:5-2, but NJSA 19:5-3, because one cannot become a member of a municipal committee unless that person is an elected member of county committee. That is the first sentence of 19:5-2. In fact, the ballot itself identified the people as running for county committee, not municipal committee. The very first sentence of NJSA 19:5-3 identifies members of county committee as those who are elected at the primary for the general election. Elected, those who are elected. The election of members of county committee must be conducted in a manner provided by Title 19. The procedures for filling a vacancy, as set forth in NJSA 19:13-20, apply in this circumstance. Consistent with that, Judge, we look at what happened here. There are 74 positions on the county committee from Cherry Hill. Due to the number of available positions on the ballot, on the machines, the election machines, the limitations of the ballot design, and the lack of timely guidance from the state, the voters were not able to select individual candidates for Cherry Hill Committee. Rather, the voters were given a choice between a slate of candidates put forward by the progressives, which fielded only 3 candidates. That was their choice. They only ran 3 candidates. And a slate of candidates put forth by the Camden County Democrat Committee, which fielded a full slate of 74 candidates. The progressives received over 5,000 votes. The county committee slate received over 3,200 votes. Each member of each slate received the identical amount of votes. Because the vacancy, and then again, as recipient of the highest vote totals, in accordance with the terms Article 2, Section 1 of the bylaws of the Camden County Democrat Committee, the 3 progressive candidates were seated as the members of the county committee at the reorganization meeting that was held. As to the remaining 71 seats, there was a tie among the 74 candidates that were on the next highest votes on the ballot. Because the vacancy resulted from a tie vote, we have to look at 19:13-20. And pursuant to that, whenever a selection is made to fill a vacancy resulting from the inability to select a candidate because of a tie vote at a primary election for the general election, as the same language from the previous section, the selection shall be made from among those who have thus received the same number of votes at the primary. This operates to ensure that the will of the voters is carried out, because failure to fill the vacancies at issue from the candidates who received the next highest vote effectively disenfranchises the 3,255 voters who gave those people their votes. And for this proposition, we rely on Philippone versus O'Connor. And it's for further good reason why the selection is from that group of people, that pool of candidates. Those individuals, in addition to the 3 progressive candidates, were the only individuals vetted to determine their qualifies to stand as a candidate. Those individuals sought and received and filed the requisite number of signatures on their nominating petitions. Those petitions there was a right to challenge those petitions, and the signatures on this, the validity of the signatures on those petitions. Each nomination petition ultimately was deemed valid by the authorities that govern such thing, and each petition was accompanied by a certification and an oath required by law. By contrast, simply soliciting people who might be interested now, instead of at the time of the primary, to fill the vacancies, doesn't give anything or any opportunity to vet such individuals to determine whether or not they can serve, or even eligible to serve, on a committee of volunteers that has the right to govern its own internal affairs. So this brings us to the matter of the quorum requirement. 3 of 74 members is 4% of the full membership of the county committee from Cherry Hill. The CCD bylaws, which were adopted by the county committee and incorporated by the Cherry Hill committee, as Your Honor sees from the certification submitted with our pleadings, require 30% of the full membership to constitute a quorum. Because there is no quorum, there is no municipal committee to act on this. So the alternatives are this, Judge. Simply the failure to have a municipal committee that's eligible to act because of a quorum could require that those 71 remaining seats remain vacant, or the selection of the people to fill the vacancies come from the pool of 71. Under those circumstances, Your Honor, respectfully submitted that the party has established its right to an injunction under the Crow criteria. But a couple other points just have to be mentioned. First, the progressives challenged the ballot structure before the primary, and the Camden County Democrat Committee sought to intervene because the progressives did not name the Camden County Democrat Committee as a party. In fact, the progressives withdrew that action before the county's motion to intervene could be acted upon. Next, it's astonishing, absolutely astonishing, that the progressives and derivatively the Attorney General's office rely heavily on the chairman of the Camden County Republican Party to opine on the interpretation of both the law and the Camden County Democrat Committee bylaws. There is and can be no demonstration of the qualification of the chair of the Camden County Republican Committee to render any opinion on the Camden County Democrat Committee bylaws. Third, it clearly appears that the progressives have attempted to use this litigation as a forum for the irrelevant, a forum for opinions and hearsay that's contained in their certifications that do not comply at law. In fact, I suspect from looking at the progressives' papers that we're going to see certain images and the like that indicate that perhaps there is a disparity as to where the members of county committee come from in the municipality of Cherry Hill.
Well, everybody should be aware that I'm limiting my decision today based upon what was submitted. That's fundamental fairness. I don't know what Ms. Bromberg intends to do. We'll say I don't know what you intend to do in your remaining time. But everybody should be, of course, aware that the decision has to be limited to the record before me. If something is not in the record before me, now is not an appropriate time for the first time for me to hear about it or to see about it, or that type of thing. If somebody wants to make a record of what they would have submitted, I'm glad to allow them to do it for appellate purposes. But I think everybody should be aware that I'm not going to consider something that wasn't contained in the paperwork.
Thank you, Robert. And the point that comes from that, Judge, is the Camden County Democrat Committee can make its own decision as to whether or not it's going to elect its members at large or by district. This is not the forum to raise that issue. And finally, Judge, the belated filing by the Attorney General's office should carry no weight. In addition to relying on the Cherry Hill Republican Party chair, the Attorney General relies at great length on an unpublished trial court decision from the state of North Carolina that neither cites nor references any New Jersey state law. So, Judge, we're here, and we've heard that the phrase that elections have consequences and that the winner takes all, and we must accept the results. However, we look at the consequence of only running 3 individuals. That consequence clearly resulted from and results in the failure to make a quorum, establish a quorum, to take action under the bylaws. Again, Judge, this is and will always be an intra-party fight, an intra-party dispute, an intra-party matter that is best resolved by the party itself. And with that, I'll leave the court with this point from Judge Wells in Hartman versus Covert, where he was citing you, again, EU. He says that the state has a legitimate interest in orderly elections, not orderly parties. If there's a dispute as to what the bylaws say, and enough people are elected to form a quorum, to make a challenge to those bylaws, within the context of the party's apparatus and the party's committee and the party's meetings, that can be done. There's a provision in the bylaws in order to how to amend the bylaws. But facts before this court here are this. There was a fair election, putting the ballot structure aside, in which the votes were counted, the votes were certified, and the 3 individuals that got the most votes in Cherry Hill were seated on county committee and given the opportunity to participate within the confines of those bylaws of that committee. That's the only issue before the court. That being such, the injunction certainly must continue in this case and should be granted as a permanent injunction. Thank you.
Ms. Bromberg?
Your Honor, if I may.
Sure.
Your Honor, thank you. I have a few points. This was not a close election. The overall vote total here was 62.5% for the 3 individuals running on the South Jersey Progressive Democrats slate. 62.5%. Now it's interesting because as we submitted as Exhibit C to Mr. Stahl's cert, we found that had the CCDC slate been elected, 58% of the municipality, and I'm just going to approach, 58% of the municipality would be underrepresented. That demonstrates that 13% of the voting districts would have had no representation. 15 would have been underrepresented, making a total of 58.
Ms. Bromberg, I'm going to let you at least summarize the argument. You've done that in the brief, and I want to give you, for purposes of appeal, an opportunity to make a record. But I don't regard this stuff to be legally relevant. We're here on a return date on a 452 order to show cause, which requires me to look at 19.5-2, 19.5-3, 19.13-20, and the record before me, which there really is no dispute in terms of the vote, et cetera, et cetera, et cetera. How all this came about, in this case has a history, goes back to the Kim-KAM litigation named after then Congressman, now Senator Kim. There was further litigation in the Superior Court concerning the structure of the ballot. And this is where we're at. Whether or not the representatives on County Committee from Cherry Hill represent a fair distribution or representation from Cherry Hill Township, I don't think it's before me. I don't think it's my role today to disentangle all of that. Right? There may be a forum for that. Mr. Tambu suggests it may be within the Camden County Democratic Committee itself to run its own affairs. But it most certainly isn't here this morning. But I want to give you a chance to put on the record your points, at least to preserve it for appeals. Okay?
Thank you, Your Honor. I appreciate that. And I would submit, because all of my points will essentially build up to the relevant pro-factors which are before us, which take into consideration the public harm and the irreparable harm by allowing the OTSC to move forward. And I am additionally, of course, as you recognize, interested in preserving the record as well. So we have 48 districts in Cherry Hill. The white districts and the yellow districts here represent under or no representation at all. The dark blue represent over-representation. And when we examined what was happening in those dark blue districts, what we discovered, what does that mean, over-representation? It was 3 to 6 candidates we discovered from their slate that would be arising from the same district. What we found when we drilled in further, and of course, Your Honor, we did not submit their addresses out of respect for the record, was that several of them were arising from the same household. So over-representation from the same household, even up to 3 people coming from the same household. In one scenario, 5 coming from the same complex. Moreover, this map demonstrates in green what occurred during the primary election this year among Cherry Hill's 48 voting districts. And what this map shows is that SJPD won 90% of the voting districts in the municipality. 43 of the 48 voting districts voted majority for Cherry Hill. The 3 that CCDC won, interestingly, were only secured by a total of 19 votes among those 800 votes from those 3 voting districts. So not only did SJPD win 63% of the overall electorate, it also was secured by 90% of the voting districts.
Ms. Farmer, let me just add something. That was replete in your paperwork. I don't mind saying it was an impressive victory. It was, I think, about 5,500 to about 3,300. But if you take out Title 19, I think you'd be hard-pressed to find any statute in Title 19 where the disposition of the issue requires the court to determine how big the victory was. Whether the victory is by 1 vote or 1,000,000 votes never matters. Winner wins, loser loses, whether it's by 1 vote or 1,000,000 votes. In other words, the size of the victory is legally irrelevant.
I agree that under Title 19, it says that the election shall go to the highest vote getter. That's undisputable. And CCDC agrees with that. They acknowledge that the 3 elected are duly elected candidates.
It's not a controversial point that the person generally that gets the most votes wins. That's
Correct.
fairly uncontroversial.
The purpose of having an election is to determine a winner or a loser. and the loser has to manage with the consequences of the fair conduct of an election. What these two maps demonstrate, and I won't overly focus on them, I just wanted to introduce them for allowing us to set the stage. I do think that they're relevant for the Crow factors, is that as the plaintiffs assert here, they say, well, how could it be that only 3 would determine the vacancies of the remaining on the committee? However, it's not only 3. It's 90% of the voting districts that elected them. Interestingly enough, even those districts where there's overrepresentation by the CCDC proposed candidates voted for SJPD. That goes to the Crow factor. It goes to the fair and safe conduct of the elections, the public interest, the injury of the public interest, and the irreparable harm, respectfully, Your Honor, that will conduct if Your Honor does not lift the OTSC today in terms of the will of the voters.
The voters, for a second. In this particular election, you had 74 open seats. You had 74 candidates. Well, I'll use the labels that the parties themselves prefer. You have the progressive Democrats, I kind of shortened it a little bit, and the committee Democrats. Everybody okay with that shortening?
Yes, Your Honor.
All right. Suppose the progressive candidates had 1 candidate. This is an alternate universe we're talking about. And the committee Democrats had 74. And the one progressive got 4,900 votes. And the committee Democrats, because they're a block, got 4,899. 1 vote difference. Okay. You still have the same arguments that you're making in regard to which statute applies. That doesn't change that. But it kind of moots any issue concerning me looking at, the geography and the demographics, that type of stuff. I mean, those factors, I think, come into play in gerrymandering lawsuits, that type of thing. What's a fair representation? But these are at-large elections. Whether or not the candidates come from a single apartment complex or a single zip code in Cherry Hill is legally irrelevant. It may be relevant within the party itself in determining how they want to elect their committee people, but it's not relevant before. I mean, if I stick my snoot into intra-party affairs, that's exactly what I'm doing. I'm sticking my nose into something where it really doesn't belong.
Your Honor, I agree that on the 4 corners, it is not the central aspect of the litigation before you in terms of the at-large versus district-based representation. I think that's very clear. However, when considering the Crow factors, I do believe that they become relevant. And respectfully, Your Honor, I do not believe that this is a mere matter of intra-party affairs. When the Voting Rights Act was enacted in 1965, the result of that enactment led to a sweep across the Jim Crow South to change the system of representation to an at-large system, knowing that it would be more difficult for district-based representation to secure fair and equal representation on those systems.
I'm not, again, my apologies for interrupting you. Assuming somebody in Cherry Hill or somebody who had standing to contest the way the Camden County Democrat Committee picked its committee people, that would be a different form than the return date on an order to show causes, basically, putting aside the temporary injunctive relief, permanent, whatever. Right, it requires me to look at 3 statutes, because nobody disputes what happened below. There really is no factual dispute. I don't know parenthetically for what it's worth. Assuming there's an appeal to this, the appellate division will give 0 deference to my legal opinions because that's the way it is. It's not a factual determination that would require an intermediary appellate court to give deference to. There are no factual disputes here. There's a legal dispute between 3 competing statutes, and you really combine 5.2 and 5.3 together. Which one is a better fit? Because the reality is, arguably, neither are a perfect fit. I'll go into that in a bit. It's an unusual type of tie. You don't normally see 74-person ties, not a usual thing. But when 2 or more people get the same vote, the common understanding is that's a tie vote. So, but again, my apologies for interrupting you. I want to give you a chance. But this is not the forum to litigate how the Camden County Democrat Committee picks its committee people.
I will get to the specifics of 1952 and 3 and 20. as it relates to construction of the legal text. But I'm responding to the arguments that were put forth by the plaintiff with regard to whether or not this is purely an intra-party dispute and not a matter of statutory interpretation. And my reference to the Voting Rights Act and the sweep, the change of electoral system to at-large systems.
Again, I'm going to give you a chance to do that, but if I sit here like a sphinx and say nothing, it kind of becomes almost physically difficult. So
Well-
the reason why I interrupt, and it's a very bad habit of mine, it's a habit I picked up several decades ago and hasn't gotten any better over time. But the reason I'm indicating that this is a case of statutory interpretation, but there are other layers to it, right? Mr. Tambuzzi highlighted that from his perspective, it is an intra-party dispute, and generally, and he cited the case law that basically says the courts generally back off and allow the parties themselves to run their own affairs, that type of thing. There are good reasons for that. So I want to give you a chance to respond, but ultimately, the disposition on a return date of a 452 order to show cause is going to be contingent upon my interpretation of 3 statutes. That's it.
Yes, Your Honor. That so-called inter-party dispute was found to be invalid by the United States Supreme Court in several respects. The exclusion of Black people from being able to run for office in terms of the regulation of the primaries, and the insistence of at-large voting systems because of the inability to have equal voting power in the elections. And so it is not the case that inter-party disputes are untouchable.
No, I'm not
By
suggesting
the
that. I'm
courts.
simply saying they're trying to shoehorn in the arguments against Jim Crow and that type of thing to the return date on this type of order to show cause, which, again, if you think I'm wrong, fair enough. That could be raised on appeal. If I did anything other than interpret 19.5-2, 19.5-3, 19.13.20, and apply it to the facts of this case, all right? A serious argument could be made that I am grossly exceeding the bounds of my authority.
Your Honor, I agree that I don't think that for the purposes of this matter before you and the nature that it's come before you on an emergency proceeding, that you need to make a determination with regard to whether or not the Cherry Hill map and the focus on at-large voting districts is constitutional or unconstitutional. What I do think merits examination and consideration is the impact of that on the public interest, particularly where the voters overwhelmingly elected. And I'll move on to the next section with regard to the statute
I
itself.
don't really feel like take as much time as you want. I just felt it was incumbent upon me to kind of rudely interrupt to indicate that I don't see those issues as being before me. I don't. And, you know, I want the record to be clear that my disposition on this return date is going to basically just applying 3 statutes. I'll also comment somewhat parenthetically on what I think would have been the result had there been no bracketing of 74 candidates and a bracketing of 3 candidates. But that's as far as I think I should be going.
Your Honor, I would submit respectful dissent to the concept, simply due to the vast impact on the majority of the Cherry Hill voters, both by district and also overall. I'll move on to the statutory points for now. The applicable portion of the statute is 19.5.2. And interestingly, 19.5.3 also, they contemplate and specify that it is, quote unquote, the remaining members of the committee who are charged with filling the vacancies, specifically as it relates to the charge, the mandate of municipal committees. Quote unquote, the remaining members of the committee are charged with filling the vacancies. Now, this statute is clear, it's unambiguous, and it directly connects with the scenario presented before us. If it were not to, then it might as well be stricken from the statute.
Yeah, but at 13 years, 20 is also on the books. And let me see if you can agree with me with the following. 13-20 serves some purpose, right?
I think that the provisions of Title 19 each serve its own
Right, so
purpose with regard to the
1320,
overall.
It seems to me the easy 13-20 case is as follows. We'll take it away from people trying to seek membership in a party committee. Let's take the more conventional primary, where you have a New Jersey Senate seat up. So you have 2 Democrats running in a primary for one candidacy to be in the general election. And you have 2 Republicans, or 3 Republicans, whatever, doesn't matter the amount. All right? And there is an actual tie vote in the primary. That's the easy 13-20 case, right?
That is the scenario with regard
Well,
to the.
actually, I may have misspoken. Actually, 13-20 does deal with party votes. But let me see if I can get you to address this. You're arguing that 13-20 just simply doesn't apply. And as I understand the argument is, you're arguing first it wasn't a primary, and secondly, it wasn't a tie, right?
It wasn't, well, there are several aspects of 1320 that I think are instructive for us.
Right. But I think what you're saying is, and I'm not trying to put words in your mouth, you'll correct me if you think I'm wrong, is that, as I understood your brief, and the Attorney General's brief, 1320 doesn't apply because this is not a primary, because the winners don't go on to run for some type of election in November, right? And secondly, that it wasn't a tie. It was a binary situation, and the progressives got more votes than the committee Democrats, so there's no tie.
Yes, Your Honor.
Right, that's a fair characterization.
I think there are additional aspects I'd like to add to that, but yes.
All right, fair enough. So I think, so if you're wrong about both, then tell me why 1320 doesn't apply.
If you're
In other words, if I determined that this was a primary, right, and I determined that, as unusual as it might seem to have a 74-person tie, actually, it's not unusual. It was baked into the what? Into the goods? There's a cliche I'm looking for. It was baked in when you bracket the candidates. But 3 people got the same amount of votes, and 74 people got the same amount of votes. The popular understanding of people who get the same amount of votes is that it's a tie, right?
No, Your Honor.
If 2 people get the same amount of votes, what would you call it?
If 2 people secured an election and won, that would
Assuming
be.
2 people are running for 1 seat, right? 2 people are running for 1 seat, and they both get 147 votes. What would you call that?
Your Honor, in the context before us, there were 2 options presented to the voters.
No, I understand your point that this situation, which Mr. Tambusi pointed out multiple times in his brief, is a rather novel, unprecedented situation. Okay, fair enough. Which is why I say the case isn't a classic 5-2/3 or a classic 13-20. But the net result is people got the same amount of votes. How they got the same amount of votes, I agree, is an unusual path.
Your
right?
Honor,
Yeah.
that a grouping of people in a vote for one scenario obviously received the same amount of votes is irrelevant for the analysis of whether or not there's a tie and whether or not there's a tie under 1320. And if I may, Your Honor, the section of 1320 is subpart C. This is completely out of bounds for our analysis today. Subpart C, and I'll read it in just for the record and then I'll break it down, provides that whenever a selection is to be made pursuant to this section to fill a vacancy resulting from the inability to select a candidate because of a tie vote at a primary election for the general election, this selection shall be made from among those who have thus received the same number of ties. Now, I count, Your
Same
Honor,
number of votes at the primary.
I count, Your Honor, at least 4, possibly 5 reasons why this text is completely inapplicable to, actually I'll say 6, is completely inapplicable for our purposes. First of all, There was no inability to select a candidate at the primary election. The voters selected. They had two options. They selected their candidate. They selected the slate before them. 2, they did not select a candidate. They selected elected representatives. 3, there was no candidate to apply to the general election. They selected 3 duly elected representatives. 4, there's no limitation here in the selection of candidates. That simply does not apply. If we look, and what I mean by that, and if you just go to the next subsection, D, a selection made pursuant, yes, Your Honor?
Okay.
A selection made pursuant to this section shall be made not later than, it's now the 68th day preceding the date of the general election. Why? Because the entire construct and focus of section 1320 is in anticipation for what happens when there is a winning tie that elects candidates to be advanced to the general election. We had no selection of candidates here. We had selection of elected individuals.
I mean,
Now-
that would be true. My understanding is that the elections that take place in June are called primary elections. The elections that take place in November are general elections. And while it's true that among elections for people to serve on committee, they don't have to run against anybody else in November, and they don't even appear in the November ballot. They appear in the June ballot, and it's called a primary election. So I kind of agree a little bit with what you're saying, in that in a cleaner situation, if you didn't have the brackets, you had 74 people who had the highest vote, 3 people got the lowest vote, they're off. The 74 that got the highest 74 votes are on. They don't run again in November, that's true, right? But they're still running in a primary. They're running in June. June is the primary. Nobody refers to the election in June as the general election.
For the purposes of electing party committee, the primary is the election, unless there's a runoff. A runoff happens if there's a tie. Other portions of New Jersey statute contemplate the sore loser law. You don't get a second bite at the apple. There's another section that actually is very interesting to me in 1320. And it's under subpart A,
Just 1 second.
and it's the first full paragraph under subpart A.
You say support, I'm looking at A1 and A2. You talking about A2?
I am actually talking about the first full paragraph under A4.
Hold on. Yeah.
Okay. At any meeting, I'm going to read it. At any meeting held for the selection of a candidate under this subsection,
Hold just 1 second. I'm looking at, we're still on 13-20, right? All right, I'm looking at A4. My A4 begins, in the case of an office to be filled. Are we looking at the same thing?
and the next full paragraph, at any meeting,
Hold on. Oh, I see, okay, sorry.
okay? So let's start just to set the table at the top of 1320, the first paragraph of 1320. In the event of a vacancy, however caused, among candidates nominated at the primary election for the general, which vacancy shall not occur, there's a timeline with respect to the general election, or in the inability to select a candidate because of a tie vote at such primary, a candidate shall be selected in the following manner, right? And then this is largely repeated of the subsection C, the top of A, the top of dash 20. Now subpart 4, essentially A1, 2, 3, and 4 contemplate how to fill vacancies depending on the office being run. So if it's a statewide office, it's selected by the state committee, county-wide office by the county committee, 2+ counties by the county committees of those requisite parts. Subpart 4, portion of a county. in the case of an office to be filled by the voters of a portion of a single county, the candidate shall be selected by those members of the county committee of the party wherein the vacancy has occurred, who represent those portions of the county which are comprised by the district from which the candidate is to be elected. Now let's go to the next paragraph. This is very interesting to me. At any meeting held for the selection of a candidate under this subsection, a majority of the persons eligible to vote thereat shall be required to be present for the conduct of business. This language is fascinating because notwithstanding the fact that there was no inability to elect a candidate, notwithstanding the fact that the primary election is the election for the purposes of the party, this section says that the persons to determine how to fill the vacancies shall be by the majority of the persons eligible to vote from that portion of the district. That is parallel with subsection 952 and 3, right? Which specify, it doesn't say the majority of the persons eligible to vote. However, because it's a completely different scenario, because you're not dealing with advancing a vacancy to go to the general election, you're talking about filling a vacancy by duly elected candidates at this point. There's no nomination, there's no candidates. They're duly elected party office holders. And 5.2 and 5.3 provide that the people to fill those vacancies are charged to be the remaining members of the committee to fill the vacancies. Also, as I put in the papers, 5.2 and 5.3 provides no specification, no comment on a tie vote, no comment about this radical notion that duly elected members are to be limited by a list of losing candidates for the selection. There's nothing like that found in 5.2 and 5.3. And in chapter 13, in 1920, 13-20, it has repeated references to 1952 and 5.3. It's embedded. So what would be the purpose of 5.2 and 5.3, if not to be applicable in the scenario before us?
I think the classic purpose, unless it's a rhetorical question, is that, and this is, if somebody is elected and dies, there's a vacancy, leaves Cherry Hill, moves to Mongolia or whatever it is. I mean, again, the monkey in the room, so to speak, is that what happened in Cherry Hill with this election, there's no precedent for it. There's no case law in terms of how to deal with it, that type of thing. I mean, we're here for basically for two reasons, because of the way the ballot was structured in terms of bracketing the 74 and bracketing the 3, and also because the progressives put 3 candidates and the committee Democrats put 74 candidates. If the progressives put 74 candidates, assuming the same type of margins, we're not here today.
There's no statute that requires that the entire bracket be full. If there was, it would clearly be a violation of the First Amendment and the 14th
Well, I'm not
Amendment.
suggesting, that was argued also, I think it was argued in the 80s brief. That of course is true. In Collingswood, my attention in the briefs was brought to Collingswood. They had to vote for 18, I think there were 18 regular Democrats and 1 progressive, right? I think that's what the numbers were. You're right, there's no requirement. But the point is that if the voters can vote for individual human beings, it doesn't really present a problem. The problem is that when they're confronted with a situation where potentially, this is what I think I asked you a few minutes ago, I'm not sure I gave you a chance to answer, and perhaps I should. If you're right in interpreting these statutes, then if there were 1 progressive on the ballot in Cherry Hill, and he or she got 1 more vote than the 74 committee Democrats, you're arguing for the same result, right? The 1 person can then basically decide the 73 others who are going to serve on county committee, assuming they meet the regular conditions of they're registered Democrats that live in Cherry Hill. I assume there's an age limit, 18, 21, I don't know, right?
Your Honor, if 1 person and only 1 person were to submit, when does this process start? The distribution of the petitions. If only 1 person were to submit and fill out a petition, or if 3 people were to submit and fill out a petition, those petitions could be challenged. The ballot draw could be challenged. The ballot design could be challenged. There is a whole setup. There's a whole enforcement.
That doesn't answer my question, and I'll try one last time. If you're right, and you might be right, if you ask three other judges, they might come to a different opinion, but if you're right, if what occurred here is one candidate is on the progressive line, you have 74 candidates under the committee line, and the progressive gets 1, 2, or 5, not 2,000 more, but one more vote than the committee Democrats. If you're correct, then everything you're arguing now is going to be equally as true, and that one person gets to pick, subject to the conditions in the bylaws of the Camden County Democrat Committee, that one person gets to pick the 73 others. You think that's a fair point?
Yes, I do, Your Honor, because the entire election code is set up to allow for that. And those are the rules of the game. And just because you don't like the outcome doesn't mean that the rules are unfair. If you don't like the rules, then you challenge and you bring the proper, appropriate party to court.
Absolutely, but...
And the county clerk, Your Honor, is not present.
Here's the thing, and I'll say this again, and I think it really is true. This is uncharted territory, right? It's not like there's a whole body of case law, published or unpublished, that instruct trial judges, appellate division judges, attorneys, litigants, party officials, as to how to go about when something like this happens, all right? And we all know why this happens. There's a history to this case. It goes back to the federal litigation, right? The law of unintended consequences probably kicked in terms of this type of result. The point I'm making is that in testing out which side is probably correct, you have to ask yourself, you have to basically create a slightly different set of facts, apply those principles, and see if you get a result that you think reflects the will of the voters. It's not so much what I think is fair. Nobody should care what I think is fair, all right? And it doesn't matter. But I'm supposed to, be concerned about the will of the voters. The voters here placed 5,300 votes for the three progressives, 5,500 ballpark, and about 3,300 for the committee Democrats. That's the only thing I know for sure.
You also know, Your Honor, that 90% of the voting districts voted for SJPD. That every single way in which you cut it, SJPD was overwhelmingly elected. We also do have a body of case law and a whole statutory code that instructs us of how to move forward.
Listen, your argument, I think would be exactly the same if, I'll keep on using the three, I won't convert it. If the three candidates won by 6 votes, and the vote distribution was statistically even throughout every block on Cherry Hill, your argument would still be the same. By the way, Mr. Dambusi's argument would still be the same also. In other words, it's not outcome determinative. The size of the victory, the voter distribution, all these things, they're nice to argue, right? But ultimately, they don't dictate the outcome of trying to interpret 3 separate statutes, none of which, it seems to me, are what I would call a perfect fit for this case.
Your Honor, I believe that 5-2 and 5-3 are a perfect fit to this case, as is 1320.
Well, let's talk about 5-2. Let's go back to 5-2, all right? You have your 5-2 in front of you?
Yes.
Right. It starts off by saying, the members of the municipal committees of political parties shall consist of elected members of the county committee resident in the respective municipalities.
Right.
And then the next paragraph begins, when a member of the municipal committee ceases to be a resident, ... So an argument can be made that the definition of a member of a committee whereupon a vacancy occurs already has to be an elected member of the committee, and then the vacancy occurs.
Membership on the committee is a being elected is a qualification for membership of the committee. And if you look at the CCD, even the CCD bylaws, obviously the statute trumps the bylaws. Even if you look at the CCDC bylaws in terms of how it defines quorum and how it defines membership, I mean, I'm sorry to it's almost embarrassing to say because it is so obvious logically. Election is a qualification for membership. These three individuals were elected. They are now the members, and they shall fill the vacancy.
Yeah, but I think the point is that there's an argument to be made that 19.5-2 focuses on vacancies that kind of occur a nanosecond or thereafter after the election, rather than a vacancy due to the structural vagaries of how the ballot was set up, which parenthetically wasn't an issue in Collins, but Collins would only get 18, it wasn't an issue. Here you had 74, and no one is contesting that what arguably should have been done couldn't have been done. It wasn't physically possible to do. And in a world where we're confronted with two less than perfect choices, you picked the less bad of the two bad choices. That's life.
Your Honor, there is an argument about that, whether or not something could or could not have been done. That is not before us at the moment on the squares. The reason that the Lampett case was, by the way, she's not present here because she was not even named as a party. I don't know even if she was served the papers because there was no certificate of process offered. So calling into question the ballot design as an excuse.
Well, I'm
Well, I'm not saying that you're calling
I'm not
it,
doing
but the
that.
plaintiffs.
Yeah.
The plaintiffs calling into question the ballot design.
No, but saying something's an excuse is kind of a loaded word. It's kind of pejorative. You know, it's not an excuse. This case has a history, right? The reason why we're all gathered here today at 10:10 on a Friday morning is historically because of the federal litigation. And I'm certainly not blaming or excusing. There was federal litigation before a district court judge, and then it went to the Third Circuit, right? There was a Superior Court action, all right? And then there's this. That's the history. And the reason why you end up with this today, I think, can be explained. Not excused, not justified, explained by looking at the historical litigation history that led up to this. That's the point.
Yes, Your Honor. And what I was suggesting is that the Lampett case itself was withdrawn because of the assertion by the county clerk that the voting machines could not allow for the ballot design. And, Your Honor, specifically, we allowed to withdraw it, and it was on the record of the court, because the election was coming up, and we preserved the right to challenge the overall system at large. No one else interceded there. No one else, in terms of brought a case against the county clerk, no one else participated in all of the opportunities that are presented in the primary election calendar for the due and safe conduct of the election administration process at every step along the way.
You understand that I'm not going to be relitigating. Maybe I'm at fault for even bringing it up. Maybe you brought it up for whoever brought it up. It's part of the history that led up to this case. But I don't think anybody seriously expects me to reopen or relitigate that resolved piece of litigation, right?
Absolutely, Your Honor.
And if you're right, if you reserve the right to contest a subsequent election based upon what happened in the Lampett litigation, fair enough. Another lawsuit can be filed. You have a 1 in 5 chance of drawing me if it's filed in Camden County Superior Court, right? There are 5 civil divisions. There will be 5 civil division judges on July 21st. But the point I'm making is that the forum today, other than obviously allowing you to give your presentation, but everybody should understand that I'm not going to be relitigating or doing anything in regard to any of the earlier litigation.
Sure. There's a pattern here, Your Honor. Heads I win and tails you lose. Heads you lose in Lampett. Heads I win anyway by bringing this challenge. And more so within the 4 corners of this litigation, you have a sufficient quorum. There's no argument by the other side that the 3 elected people have the quorum to fill, satisfied quorum to fill their requirement.
I want to make sure I understand that, all right? I have a layperson's understanding generally of what quorums are. My understanding of the Camden County Democrat Committee is that the committee as a whole requires a 30% quorum, right?
Yes, overall,
Okay.
yes.
And what the paperwork indicates, and your clients aren't disagreeing with, is that the practice is within the municipalities is to follow that model, which would be 30%. That's what the paperwork says. In other words, I forget why Mr. Land, L-A-N-D, was cited for how the Camden County, the Cherry Hill Republican Party does things, but Mr. Tambusi's paperwork reflects that it's a 30% quorum requirement for county committee, and apropos to this case, that is the practice within the municipal committees, 30%.
Your Honor.
So, yeah.
The bylaws provide, and I'm quoting from them, 30%
Oh,
of the...
before you quote from that, let me pull out my bylaws copy. Just one second. Okay, which section of the bylaws?
You mean where they are in the record?
Yeah, I have, it was Exhibit A to the verified complaint on the order to show cause. That's my copy.
So it's under Article 3 of the
All right,
bylaws,
Just one second.
which should be found at the bottom of page 2.
On page 2.
Article 3 is just the heading. It continues on to page 3, at least on my version.
All right, hold on. I'm looking at it today, in my copy, it kind of starts out on page 19 of 80. But if you say it's Article 2, that should
Okay,
be...
19 of 80.
Well, I got Article 3, I found Article Roman numeral 3, I got it. Okay,
Right.
which section do you want to refer to?
Right, so if you were on 19 of 20, then please, Your Honor, look at top of page 22.
All right. Yeah, that's the language.
Right.
It says paragraph 30, open parentheses, 30, percentage signal, close parentheses. Percent of the full membership of the county committee shall constitute a quorum for the transaction of business, comma, subject to the limitations set forth in Article Roman numeral 10.
Right, 30% of the full membership. How do we know what membership means? Well, thankfully, CCDC provides a definition of membership. It is on page 19.
All right, hold on. Yeah, I got it, right.
Article 2, membership term and vacancies. The first 3 letters, the elected members of the county committee shall be elected. Election is a qualification of membership. So therefore, for the quorum to satisfy 30% of the full membership, and membership, election is a qualification for membership, then when the 3 duly elected members met, there was 100% quorum.
Well, that's true as a matter of statistics. But I think it argues against the spirit of a quorum, and I'll explain myself. The plaintiff's argument is that the 30% is 30% to 74, right? I think that's their argument, right? If you go back to my example of one person, and there's a reason why I'm going back to that, right? In part because in Collingswood, it was just one person, right? Collingswood is a smaller municipality, so maybe as a percentage of the overall population, 1 is bigger than 3 in terms of the 80,000, whatever it is in Cherry Hill. But the point is this, is that the reason for a quorum primarily is to make sure that whatever decisions are made within that group, that it kind of reflects the will of the group. Right, so if you have a group of people that at full membership is 80, and because not all 80 people can attend every single meeting, that type of stuff, the reason why there are quorums is so that any business conducted by the 50 that show up, the 30 that show up, or in the context of a 30% quorum, the 25 that show up, all right, kind of reflect the will of the 80 to some extent. In your situation, if you're right, one person gets elected, obviously one person is 100% of 1. It's a lifelong built-in quorum, right? And if you have 3, you're right as a matter of the math, if one person shows up, that's 33%. There's always going to be a quorum. So you're right on the math in that regard, but I think that contradicts the spirit of why any organization, putting aside political parties, any organization that has some type of quorum requirement, it defeats the purpose of having a quorum requirement.
Well, Your Honor, if one person was elected with 100% of the vote, that is reflecting the will of the group. So taking an example where you select one person,
Yes, and by the way, I've actually thought about that. I said to myself, what could the three progressives have done to avoid this situation, other than obviously having 74 candidates or something like that, all right? Just the three. Let's assume the vote had been around off 5,500 and 3,300. That's 8,800, right? 5,500 plus 3,300, 8,800. Anybody think my math is wrong? All right, let's assume the vote was 8,800 to 0. To 0, all right? That would be a rather striking result, all right? And an argument can be made, you don't need to worry about brackets, okay? Nobody, not a single registered Democrat who voted on June the 10th, 19th?
Yes.
All right, wanted the 74 committee Democrats, okay? But once you get a number above 0, then you're factoring in the will of the voters, because it wasn't 100 to 0, that type of monolithic vote, all right? So that's the difference. So in that context, if you have three that got 100% of the vote and they're sitting there looking at each other and saying, geez, how are we going to conduct any business? You know, we're never going to get, well, one point is that they will eventually, if your clients are right, they're going to fill the 71 of the seats, and they're going to need 30% of the 74. I think that's the way it works its way out.
Your Honor, there is a complete logical incoherence in the argument being presented by the plaintiffs, and it's this. They acknowledge that the three candidates can fill the vacancies.
Right. Just because it's
Hallelujah, we have a quorum.
Yeah, but the problem, there's, of course, there's a rather large asterisk next to it. Much like Roger Maris, when he had an asterisk next to his name, when he had 61 home runs, and they put in, 162 game season and forever, there was an asterisk. The asterisk is that the plaintiff's position is, yes, they get to fill the seats, but they're somewhat limited in the choices they can make, right? Because they have to pick from the 74 committee Democrats. That's what they're saying.
There's nowhere in the law that requires that.
But that's in 13-20.
Where is it, Your Honor? Because 13-20C is related to the inability to select a candidate due to a tie that to be advanced in the general election. That's what 13.C is referring to.
Hold on, you asked me a straightforward question. I'm going to try to give you a straightforward answer. Hold on. Section C.
Right.
Section C, whenever a selection is, I'm talking about 1913 years, whenever a selection is being made pursuant to this section to fill a vacancy resulting from an inability to select a candidate because of a tie vote at a primary election for the general election, the selection shall be made from among those who receive the same numbers of vote in the primary. I agree with you, it's not a perfect fit. I don't doubt that. However, having said that, if the plaintiffs are right, there were 74 people tied either for 4th place or for 74th place, all right? And that pursuant to Section C, they're the ones who have to be selected to fill the vacancies. But that's where the language is. You can argue that the language is inapplicable, fair enough, right? But that's where that is where the statutory support comes that undergirds the plaintiff's arguments.
Right. And it's completely inapplicable for the reasons I stated before, because of the 6 reasons. Now also, in 1320, the section that I looked at before, at any meeting held by the selection of candidate under this subsection, a majority of the persons eligible to vote thereat shall be required to be present for the conduct of the business. If we are to read 13C in this way, which is completely inapplicable here, what would this section would apply to? Any meeting held for the selection of a candidate?
Again, I'll answer the question. Basically says, and this is contained in the proposed order that Mr. Tembusi submitted with his order to show cause, that the three progressives, by a majority vote, pick, I think, he can speak for himself obviously, but pick the 71. And it's by a majority vote. That's the statutory provision. Look, somebody's got to, look, either there's a whole nother election and nobody is asking for that, thankfully, right? Or some human being or some amount of human beings have to pick to replace, to fill the vacancies.
The way in which the plaintiffs have proceeded has been on all four corners of 1952, which governs that duly elected people, are elected representatives, are to fill the vacancies from among the remaining members of the committee. Again, Your Honor, the pattern of heads I win, tails you lose. We saw it in the prior litigation, and we see it here as well. This is an argument of convenience, and it is completely internally inconsistent in logic. Now, before I go specifically to the Crow factors, the question about...
Let me interrupt in regard to that. Crow versus DeGioia, some people pronounce it with a soft G, or Crow versus DeGoya, some people pronounce it with a hard G. And since I assume that either Mr. or Ms. DeGoya has long passed away, I can't ask them how they pronounce their name. But however it's pronounced, almost certainly would apply to any request for preliminary or temporary injunctive relief. If the plaintiffs are correct, they're requesting that I order something that the statutes require, or that is required under law. Okay? It no longer becomes a situation where we turn the clock back 8, 9, 10 days, and I have to decide whether or not, in essence, to freeze the status quo pending hearing from both sides. Right? So I'm not sure that it's a Crow situation anymore. I'm going to allow you to address it. I have to reread Crow to see by its very terms whether or not it applies to all injunctive relief, which probably it doesn't. The Chancery Division, generally speaking, when somebody is only seeking only equitable relief, it goes to the Chancery Division. If somebody is seeking both equitable relief and monetary damages, it goes to the Law Division. And most people are aware that Law Division judges can grant equitable relief, the Chancery Division judge can grant monetary damages, although there's no jury, a place for a jury in the Chancery Division courtroom. So I'm glad to take that point up, but basically what the plaintiffs are seeking is a declaration from me that the three progressives be ordered, or that, I think one of the terms was to allow Chairman Beach, the chairman of the Camden County Democrat Committee, to order or instruct, whatever verb would be appropriate, the three progressives within a certain timeline to pick the 71 remaining Cherry Hill representatives to county committee from the 74 that were on the ballot. Okay? And I'm not sure that we're still under Crow if I determine that the statutes are a bit more consistent with his theory of the case than your theory of the case. I'm not sure that's a Crow situation anymore.
Well, we're in a Crow situation because as of today, the OTSC is still in place, right? And the TRO is still in place. Now, what was requested in the TRO? Because I do think it's relevant also for the question about preliminary relief, which is a standard of substantial likelihood of success on the merits.
Can I ask you just a quick question? Assume that the plaintiffs were correct in their statutory interpretation. What would have been wrong about granting injunctive relief?
Your Honor, we were notified of the temporary restraint of an election from the news reports. We were notified that the OTSC was signed by the news reports. It was put into place, it was requested from Your Honor after the three candidates had already met, after they had already enacted bylaws, which they sent to the plaintiff, and even before that, they requested the bylaws. There was no response. There's still been no response. The response we received was through litigation, not as the statute provides, right?
Superior Court judges get orders to show cause every day. Here's the problem. Right? I don't want to pontificate too much, but I can't resist a little. They're always ex parte, right? They come in ex parte, right? And frequently in the family division, I can bring back some old memories, right? Judges every day get orders to show cause. Frequently it's one parent saying the other parent is doing something dangerous that's going to impact the safety of the child, and they seek emergent, immediate, temporary relief, right? The judge has to decide on the basis of the certification of the affidavit in support of the order to show cause, the verified complaint, if it's under 452, whether or not he or she, the judge, feels comfortable in granting that temporary, immediate, injunctive relief on the basis of only one side's version. That's all the judge is getting, one side, right? That is structurally flawed, right? Because no decision should be made until all sides have had an opportunity to pitch in, so to speak. But 452 envisions exactly that. Judges have to do a balancing. Crow, obviously, is one of the original cases that discusses the four elements, that type of thing. But the main point to remember here is that you're right, there's presently injunctive relief. But right now, both sides have briefed the issue, three sides. All right, the issue is before me. I have to make a decision. And the question I asked, and you seemed a little bit reluctant to answer, so I'll ask you again. Right? Assuming the plaintiffs are legally correct in their interpretation of the three statutes in question, what would be inappropriate about keeping the injunction?
The fair and safe conduct of the election is at issue. This is the fundamental right to vote. This is the premise.
Even if they're right?
Well, Your Honor, you've acknowledged that there's an open question about whether or not they're right.
No, I didn't say open question. That's not maybe not an unfair. I'm saying that it is an unprecedented issue, and that the disposition didn't sound to me like a complete slam dunk either way. Right? I deal with issues all the time where I'm kind of wondering why it's even before me. Right? This is not one of them. This is a novel issue. Right? The points that you've made, the points that the AG's office made, they're not frivolous points. They may not be meritorious, but they're not frivolous points, right? As I said before, I suspect there's going to be an appeal, and 2 or 3 appellate division judges will take a clean look at all this, and they'll make their own determination without regard to what I've done. Having said that, you can certainly say that the plaintiffs are wrong on their interpretation. You've done that. But if they're right, injunctive relief follows from that disposition. That's the point I'm making, is that if they're right, there's nothing wrong with maintaining the injunctive relief that's contained in the TRO.
But Your Honor, the standard is not if they're right. The standard is if there's a substantial likelihood of prevailing on the merits. And based on Your Honor's explanation of the current situation that we're in, respectfully, what I'm hearing is an acknowledgement that there's potentially not a substantial likelihood of them prevailing on the merits.
Other than quibbling you on what substantial means in the context when you've gone beyond the initial preliminary injunctive relief, is that one side is going to win, one side is going to lose. There's no way to compromise it in that regard. And the point I'm making is one of modesty, is that I've made mistakes before. I have a 24-year track record. I've been affirmed by the appellate division. I've been reversed by the appellate division. The point I'm making is that this is a legal issue. It's not a factual issue. Okay? Nobody's going to be deferring to my legal conclusions. Nobody should. I say nobody. The intermediary appellate court of the state of New Jersey, the appellate division, will make their own determinations. That's all. And this is a novel issue. This has not been addressed, as far as anybody knows, by any previous court. And Mr. Tambusi was right, parenthetically. Nothing against the Attorney General. By the way, I'll note that the Assistant Attorney General in charge of this case decided not to make an appearance. They wanted me to consider their brief. I did. But they declined the opportunity to come here this morning. That's their decision. They did cite a federal district court case out of North Carolina. It's not published under Rule 136.3. Does not even constitute precedent. All right? Doesn't. All right? So there's nothing out there There's nothing,
Your
right?
Honor,
Yeah,
that brief that they included, I believe it was Exhibit B of their amicus brief, is a cogent analysis. It is actually the most in-depth analysis in the nation of what happens when the rules of the game are changed after the conduct of the election.
but nobody's, that's setting up a straw man. Here's the thing, if Mr. Tambuzzi was so bold as to get up and say, I know they won, but we want you to retroactively void the election, because we don't like the fact that they won, and we want to change, but nobody's arguing that. You have a set of circumstances that have never been confronted before. All right? But the point I'm making here is this. Whatever the briefs say, and I understand there's an internecine battle here, and there may be some raw emotions on both sides, that type of stuff. I don't think anybody here has acted in bad faith, all right? In terms of the election, in terms of the briefs, that type of stuff. Everybody has a position to argue, and the point I'm making is that nobody's position is frivolous, but that only one of them can be meritorious. They can't both be right.
Your Honor, there may be no one standing that is so bold, using your terminology, as to say that these people should not have been elected and to void the overall election. But the impact of that is voiding the overall election because...
I want to address that. Pardon me, and then I promise you, I'll let you speak, and I'll resist any temptation. I thought about that too. Let's go to a different universe. This election occurs on June 10th, and miraculously, there doesn't need to be bracketing of the candidates. Okay, it's done the way it's always been done. Okay, what's the result? The result almost certainly is the progressives get the 3 highest votes, and among the 74 committee members, 3 people finish 75th, 76th, and 77th, and they do not serve on the Camden County Democrat Committee. Right? That's what would have happened.
Your Honor, that's not accurate, respectfully, because the ballot itself, it could have been a scenario where the voters selected the 3 and then wrote in candidates,
Okay.
right? And then it wouldn't be a question of 71 other seats
Fair, that
going
could
to the
happen.
other
I
slate
agree
or
with
the
you.
other
I agree with
individuals.
you, but what I'm saying, I agree with you, okay? And I don't know, I honestly don't know the historical record when people are voting for county committee as to what percentage of voters are unhappy with the choices in the ballot booth, so they write in their own candidates. Having said that, all I know for sure is that in the context of this case, again, I'm going to rough the numbers, 5,500 to 3,300. And it seems to me if this election had occurred without the brackets, the progressives get 1, 2, and 3. They get the 3 highest votes. And then you have 4 through 74 with the committee Democrats. And the 3 lowest voting committee Democrats will have to wait for another opportunity to serve on the Camden County Democrat Committee.
Your Honor, it's circumspect because the voters could have written in other candidates anyway. They didn't have the opportunity to do that here.
Agreed.
And everyone played by these rules of the game. Now, although no one may be standing and being so bold, using your Honor's terminology, to say this election is void, the intention almost doesn't matter. The effect is to void the election. The effect is to relegate the 3 duly elected candidates to become only 4% of the entire county committee and to put in 93, 96, or 97% of the remaining. That is not what the voters chose.
I know that argument, I know I just violated my own promise. When you only run 3 candidates, okay, your best case scenario in regard to 74 seats, generally speaking, your best case scenario is that you're only going to win 3 of the 74 seats. That generally is your best case scenario. Your worst case scenario is you win 0, okay? But if you run 3 people for 74 open seats, as commonly understood, the best you can do under normal circumstances is 3 of the 74.
Your Honor, it would not be 3 over the 74 if there were write-in candidates. Also, these were the rules of the game.
No, that's wrong. That's wrong because even if all the vote, even if there are writing candidates, if the progressives have a slate of 3 for 74 seats, the best that they're going to do is to win 3 of the 74 seats. You're right. The voters can write in any number of different names, fiction or real human beings, whatever it is that people do when they write in names on a ballot. But as for the progressives, the best that they could expect is to win 3 of the 74 seats. That just seems elementary.
I think that this is a question of who you're defining as running and who the voters are being elected for. The 3 candidates, the electeds, now comprise the Cherry Hill Municipal Committee. The question is, what is the will of the voters? The voters exerted their will. They voted for the, you know what? This election, as you recognize, does not come in from a vacuum. There has been international coverage, national coverage, certainly statewide coverage, this entire last 16-month period about what fair conduct looks like in elections, what ballot manipulation looks like, what the will of the voters. We had the first competitive primary in New Jersey history. You might not like the outcome, but this has occupied the entire ecosystem. People are running for office and they're voting for their electeds based on that ecosystem. It is not coming out of nowhere that 90% of the voting districts in Cherry Hill have voted for 3 people. That is not, and while there is a uniqueness in terms of the manner in which this is being presented to the court, first of all, the emergency basis of it, that didn't have to happen. There is, but putting aside the procedural aspect, while there is a uniqueness in the substance of what's being presented, overall, the New Jersey courts, there's a long history of case law regarding what the plaintiffs assert is an inter-party dispute because it's their best argument. The case law directs that where there's a conflict or a violation of the statute, that the statute applies. And here, there's no substantial likelihood. That's the standard. Substantial, their ability to assert a substantial likelihood of success on the merits is just not here. There's a clear section of the statute, 5.2, that applies. 5.3 can inform the interpretation of 5.2. 5.2 is specifically for municipal committee. And even in 1320, they say the majority of the electeds, when there's a tie, when it goes to the general election, when there's a candidate, and it incorporates reference to 5.2 and 5.3. So it cannot be said that there is a substantial likelihood of success on the merits given where we are, and there's no reason to go for an emergency decision here. There's no reason to grant the injunction. What is the harm that's being asserted? The OTSC currently prohibits 3 duly elected candidates from attempting to fill the 71 open seats. What does that mean? Does that mean that when the residents of Cherry Hill approach them and say, I want to be involved, you guys are inspiring me, we need this here, we need that there, that they can't speak with them? That they can't speak with the residents that have elected them? Attempting to fill, this is vague, it's ambiguous, and it has a chilling effect on duly elected representatives. They can't conduct, according to the OTSC, an organizational meeting. I'm not sure what that means. Obviously, I had to meet with my clients to prepare for this hearing.
Yeah,
An organizational hearing, adopting the bylaws, Your Honor. They already adopted bylaws.
I agree that however you define language, you could then need to further define the words that define the language. In other words, you get yourself into a vicious circle. By trying to define A, you use words. But what do those words mean? And on and on and on. I don't think, look, I'm the one that the plaintiffs would come to if they believed there was a violation of the TRO, and if somebody claimed there was a violation because you met with the three progressive candidates, and that's all that was occurring, that would be a very easy issue to resolve, all right? So the import was to basically attempt to freeze the matter until there could be a decision on whether or not the statute means that the plaintiff's position prevails, or the statutes mean that the defendant's position prevailed. That's all.
And there was no indication or proofs offered to satisfy that applicable standard of relative hardship. Even if they went over and filled the vacancies, even if they did, by the way, as we put in the certs, the response by the community, school teachers, counselors, all kinds of incredible community leaders, they want to participate.
Yeah, but this is where Mr. Camden-Uzzi's objection, both on the basis of relevance and the basis of whether or not all this is first-hand knowledge. Just imagine a world where, assuming that stuff was relevant, assuming it's not, assuming it was, how do I litigate that on a return date of a 452 order to show cause? In other words, are we going to have, there are about, what, 78,000 people in Cherry Hill, give or take, something like that. Anybody know the exact number? There's a lot of people in Cherry Hill, all right? To try to determine the enthusiasm level of 78,000 people in conjunction with resolving an order to show cause, it basically just requires me to look at a handful of statutes, all right, would be a very, very bad fit. And I appreciate those certifications, all right, but how do we litigate that? I mean, you can call various human beings to the witness stand and say, how do you feel about the progressives? How do you feel about the committee Democrats? Do you want change, et cetera, et cetera, et cetera? I mean, we could go through that, but we could spend days, weeks, months hearing from thousands of Cherry Hill people what their desires are, and we're still back in the same place. It's not legally relevant. The only thing legally is relevant are the votes, right? Now, the votes favor your client in the sense that they got 62% to whatever it was, okay? Fair enough, right? But everything else is kind of like white noise, so to speak. It's background stuff that may be true, but it's legally irrelevant.
Your Honor, the Crow factor provides irreparable harm will occur if the relief is not granted. There's been no proof offered by the plaintiffs of irreparable harm. The Crow factor provides that the public interest will not be injured by the grant of relief. Here, it's clear the public interest favors our side. And the third Crow factor is the relative hardship to the parties favors relief. There have been no proofs by the other side to assert public interest. There's been no certifications by them that assert public interest or relative hardship. Allow them to proceed and to fill the vacancies. And if Your Honor does not rule with us, and the appellate division agrees with you, then those 71 people will become active members, supporters, and the other 71 people will simply waive in. Where is the substantial likelihood of success on the merits? Where is the relative hardship? There's been no proofs. The proofs are relevant. I would submit, Your Honor, it's not white noise. The proofs are relevant because the factors require a proof of public interest. There is no greater public interest.
That's built into, here's the thing. The Superior Court gets orders to show cause seeking injunctive relief. I'll give you an example. Somebody signs an employment agreement that contains a restrictive covenant. Anybody not familiar with what a restrictive covenant is? All right. The employer comes to court on an emergent order to show cause saying, we fired the employee and now he's competing against us in violation of the restrictive covenant that he signed, she signed, all right? And if you don't sign this order to show cause for immediate injunctive relief, he or she is going to steal customers, steal business, that type of thing. That's the conventional Crow versus DeGioia analysis in terms of what do I have before me in the verified complaint, how much is the earth going to spin off its axis if I don't grant the relief, et cetera, et cetera, et cetera. In election law matters, they're treated a bit more differently. all right? Whether they should or shouldn't is a value judgment way above my pay grade. Having said that, the seriousness of which courts should take election law disputes, that type of thing, they go to the, I don't want to sound sanctimonious, but they go to the very essence of democratic values, all right? The importance of them and making sure things are done correctly, as best as any trial court judge can assess or any appellate division, whatever, that's built into the importance, so to speak, in regard to trying to keep the status quo until at least both sides have had an opportunity to air their grievances, so to speak, in courtroom 32.
Your Honor, my experience with election law matters in New Jersey is that I've had an opportunity to appear before the OTSC is signed in terms of the deliberation and consideration. Not always the case, I acknowledge. That's been my experience, that I've had the opportunity to be noticed that the complaint has been filed. I've had the opportunity to appear before Your Honor, even via Zoom or by telephone if there's an emergency basis. That opportunity was not granted here. After the conduct of an election, usually, and the code allows, you go and you get an OTC. If you want to challenge the petition signatures, if you want to challenge whether or not the clerk did or did not conduct a ballot draw, if you want to challenge the ballot design, and those are contemplated not to happen after the conduct of the election. It's intentional that that safe harbor is established before whatever the analogy is, before the cat is let out of the bag or whatever it is. It happens beforehand. It does not happen after.
Take as much, how much more time do you think you're going to need? Ballpark, just ballpark. The reason I'm asking is, for some people, I am stretching their patience or something else by not giving us our mid-morning break. All right, can you give me some idea of how much longer you'd like to be?
Your Honor, I think that I would just like to summarize my points and then
Right.
and then answer any questions.
Do you want any rebuttal, Mr. Tambuzi?
Very short, Your Honor.
All right, here's what we're going to do. Let me give you a chance to finish your thoughts. We'll take a short break. I'll give Mr. Tambuzi an opportunity to give his rebuttal. Ms. Brommer, I'll give you an opportunity to give your rebuttal. And then I'll give my findings of fact and conclusions of law. And then life will go on. All right, go ahead.
Okay, Your Honor, thank you. I'll summarize my points, and I'll make sure also to offer some specific responses, and then we can reserve. And I would like to take I would like to reserve time for the SIR rebuttal also. 1, this was not a close election, 90% of the voting districts. 2, the statute is unambiguous. It provides for filling of vacancies by the remaining members of the committee, and separately also by the majority of persons eligible. Subsection C, completely inapplicable in the scenario before us. 3, the statute takes precedence over the CCDC bylaws. And even if you look at those bylaws, the qualification of membership is for the election of them. 4, the ongoing pattern, heads I win, tails you lose. We saw it before and we see it here also. 5, the Crow factors are not satisfied. The OTSC is overbroad, was provided too late in time, and has an effect of chilling, and it's against the public interest. And 6, the retroactivity of the election laws. This is a radical that after the conduct of an election, duly elected members cannot go on their business. And even if they were to continue to fill the vacancies, that could always be reversed later. The public duly elected them. I want to acknowledge, Your Honor, that a party here is not present, the county clerk itself. The plaintiff's opportunity, they're the master of their own complaint. Where is the clerk? They've made many allegations about the ballot design. She is simply not here. NJSA provides, 1953, that the county committee is different than the municipal committee. That's Botempo v. Carey, 64 NJ Super 51, 1960. They are separate entities. And as a reminder, Your Honor, the prior Lampett case was decided not because of I just want to make sure it's preserved for the record, not because of an inability to design the ballot. That was what was purported. But the reason that it was withdrawn was simply because the election was approaching. It was not, certainly not a finality, and we reserved for future litigation the question. And while some aspects of the case presented may appear novel, there's a long history, including Hartman. In Hartman, which was referenced earlier, the Supreme Court invalidated the party's bylaws based on an interpretation of the statute. The statute and the Constitution took precedent. This is not a simple case, Your Honor, of some civil contest. This is about the fair and orderly conduct of our elections and the question about fair representation. The voters are to elect representatives to advance their interests in the best interest of the voters. The voters so did. They elect the municipal committee members accordingly for the municipal committee members to continue in their interest. And my clients have done an extraordinary, potentially unprecedented job in engaging in the voters and the residents to be active members of the party. Despite the contest by the plaintiffs, it's simply not true that they sought to outright exclude or disqualify the 71 people. They said, participate in the process. The voters didn't elect you, but participate in the process. And here is for everyone to engage in an open process. We are going to have an open mind about this. That has never happened. That's democracy. It's democracy in action. And that's what the voters elected for. Your Honor, I'll reserve until later for reply. Thank you.
Very good. It looks like it's, that clock is running a little bit fast. Looks like it's about 9 of. Let's resume again at 11:10. We'll hear from Mr. Tammuzzi. You can take as much time as you want, Mr. Tammuzzi. Ms. Bromberg will give you an opportunity to respond. Take as much time as you want. And then we'll finalize the matter. All right?
Thank you, Your Honor.
There we go.
Thank you.
Thank you. Please be seated. Waiting for that to stop blinking. Have a seat, have a seat, have a seat, have a seat.
Ever since Monday, I've been having issues with this.
Ah, are we now on the record?
Yes, thank you.
Are we sure?
Positive. Let me hear you.
All right, Mr. Tammuzzi?
Thank you, Your Honor. Judge, there's a couple things that I just have to address on the record to make sure that the record is clear. No, the county clerk is not present. The county clerk is not a party. The county clerk is not taking a position on an intra-party affair. That's not to say that the absence of the Attorney General is not noted also. And the Attorney General's office is, in fact, lobbying its opinions into the courtroom through its pleading here. And that opinion deals with the intra-party workings of the Camden County Democrat Committee. That party, who did seek to intervene, states that they'll take no position on the interpretation of the county bylaws, and then promptly opines on the interpretation of the county bylaws. So I think that that's important to note for the record. In addition, Judge, with regard to service of the matter on Ms. Bromberg, in accordance with New Jersey court rules, this matter was filed, it was brought before the court in the manner that the rules require, and it was served on the parties. We had no indication at the time that we filed it that Ms. Bromberg was representing the parties. Sure, she had represented the parties in the past in another matter, but who are we to assume that she was going to represent them in this matter too? So for that reason, Judge, the comment or the suggestion that somehow service was delayed or otherwise should be disregarded. Most importantly, though, Judge, most importantly, as I mentioned before, this case is about the right of the Camden County Democrat Committee to run and conduct its own affairs. When we talk about impairment of a right, when we talk about the Crow factors, people seem to ignore the fact that the political parties in this nation have a First Amendment right to association. And that First Amendment right to association, as the Supreme Court has recognized, allows the party to conduct its own affairs in the way and manner in which it chooses, as long as it doesn't impair on, as Ms. Bromberg raised, in discrimination against people of color, for which there's no indication here at all. What we're talking about here, Judge, is the First Amendment rights of the Camden County Democrat Committee to associate with whom it wishes, consistent with the statute. And the statutes that are at play here are exactly the ones that the court has referred to. And those statutes, under those statutes, the three people, the three individuals who received the most amount of votes in the June election, the primary for the general election, those words all written together in the statutes, the same statutes, those people were seated and took their place in the Camden County Democrat Committee. There's no attempt to void that election. There's no attempt to challenge that election. There's no intent to pull those three people out of the county committee. They're members. Just like years ago, 2, 3 years ago, 4 years ago, there were 4 members of the committee from Merchantville. Those people were seated. They were recognized. And the same is occurring with the 3. But because there were 3, and because we've heard so many cliches in this case, the one that we should focus on is the fact that elections have consequences. Because there was a consequence in running only 3 people for 74 spots. There is a consequence. You would never have more than 3 votes on the county committee for these 3 people. Sure, there's a possibility that there could have been write-ins. Sure, there's a possibility that somebody else might decide to move, change allegiances or otherwise. But those are all possibilities. What is fact, what is the consequence, is by deciding to only run 3, you did not get the place in the County Democrat Committee under the bylaws that were duly enacted to decide matters without a quorum. And there wasn't a quorum here. They can't have a quorum. They can't have a quorum to conduct business. Now, when we look at this, when we look at the consequence of having the 3 seats, we look at the statutes and we try to fit as best we can under the circumstances presented to the court. What happens under the particular set of circumstances that are here? And we use the words. We use the words of 5-3. We use the words of 5-3, which indicate that the 5-2 membership is derivative. And we use the same words that are in 5-3 that are in 1320 to determine how best to preserve the franchise, to preserve the indication of over 3,000 voters in Cherry Hill, by giving them the opportunity, giving, pursuant to the bylaws, the chair the opportunity to direct the 3 to appoint 71 of the 74. It all comes together, Judge, and it's clear and it's simple, and it's not nearly as complicated as the progressives would like to make it. This is not an election for public office. It's an election for a position within a statutorily recognized association of volunteers, which is entitled, under the law, under its First Amendment rights, to develop its own bylaws to conduct its business. That's all that's before Your Honor. Thank you, Judge.
Thank you. Ms. Bromberg?
Your Honor, just a few points. I think the New Jersey Supreme Court's recitation in Stevenson v. Gilbert, 13 NJ 496, 1953, is helpful in terms of appreciating the legislative history of the regulation of party primaries in New Jersey, and specifically,
Oh, just one second, Ms. Bromberg, you might be speaking a little bit too softly. We have to pick you up on the audio. If you don't mind, even if you're not that comfortable, you know, don't think that I think you're yelling at me, that type of thing, but we're having some difficulty picking you up.
okay, I have two young boys, I'm happy to project. So the legislative history set out by the New Jersey Supreme Court in Stevenson v. Gilbert, 13 NJ 496, in the year 1953, is helpful to remember in terms of the state's regulation of party primaries. And the reason that that regulation came about was, quote unquote, because of public dissatisfaction with the political manipulation of conventions. They have been largely superseded by direct party primaries. The purpose of this legislative scheme is to avoid manipulation. The statute is very clear. The voters were very clear. They looked at the 2025 ballot, and they had an option. And they selected 3 candidates. And by the plain appearance of that ballot, they chose not to select the slate of 74. Their vote for the 3 was just as important as their decision and their vote not to select the 74. By going with the plaintiff's interpretation of the statute as applied here, it effectively disenfranchises 64% of the overall voters in Cherry Hill, 90% of the voting districts in Cherry Hill, that made their selection clear and unambiguous in the election. By going through the process, if the relief were to be granted in favor of plaintiffs, the outcome of that would be relegating those elected 3 to hold only 4% of the Cherry Hill committee seats. And allowing the 71 to hold 96% of those seats. That was clearly not the will of the voters. They voted for change. And that vote for change did not happen in a vacuum. It happened in an ecosystem. I want to briefly respond to some of the points raised. To suggest that the absence of the AG at this oral argument is notable, I think should be given no effect and no attention. The AG took the unique position of taking a position in this matter, and his amicus brief and his interpretation of a state election law should be not only duly noted, but guiding here. To suggest that that is equivocal to the fact that the clerk is not present or engaged is a fallacy. On information and belief, the clerk was not served and has not seen these papers. Regarding Mr. Tambusi's assertion with regard to the service of the matter, it's true that Mr. Tambusi may not have known that I was their counsel, but he knew who the parties were. And the CCDC has their contact information, and certainly the municipal clerk does, and the county clerk. And so they were not served when the verified complaint and the OTSC was filed. In Rena Margulis's certification, paragraph 16, it's she that puts in the certification that she received notice of the case and the grant of the order to show cause after after it was entered, and we've received it by the news. And everyone has email addresses, but they received the papers days later. I don't recall specifically, I believe it was 2 days, the actual service. Third, with regard to the right of CCDC to associate with whom they wish. Who is CCDC? CCDC is permitted by the state to have access to the public coffers in terms of voting machines, printing of ballots, the regulation of the primary ballots by the municipal and the county clerks. And they're permitted that because that's who the voters decide to associate with CCDC and to comprise CCDC. And the voters elected the Cherry Hill Municipal Committee members to be a portion of the county committee. So this question about what is the right of CCDC to associate with whom they wish. My question is, who is the CCDC? Because it's very clear that the CHDC is present before us today, and they have the right to not associate by not having to run 71 other candidates. It's the First and 14th Amendment protection that Judge Karashi and the Third Circuit acknowledged. And they also have the right to associate, and according to the statute, they have the right to fill those vacancies. They have a legal requirement to fill those vacancies if they're so constituted. And all they want is the fulfillment of their legal obligations to perform the duties that the public elected them to do. So with that, Your Honor, I'll leave it at that. Thank you.
Thank you, Ms. Bromberg.
I agree this really isn't all that complicated. You had a result that occurred because of an unusual bracketing on a ballot. But before we go into the statutes, let me just state some basic propositions that I don't think is all that controversial. It's true that the 74 committee Democrats getting the same amount of votes was because of the bracketing, but it's still a tie vote. That's why I asked Ms. Bromberg a couple of times what she would call it if two or more candidates got the same vote for one position. It's called a tie. That's what it's called. You can argue that the legislature, when they promulgated 13-20, did not envision this situation. That's probably true. But that's up for a higher court to determine in terms of whether or not it should be applied differently. This looks like a tie to me. There were two ties. There was a tie for first, or a tie for second and third, and there was a tie for a fourth through 74th. Additionally, the election in June was a primary. It's true that nobody went on to a general election in terms of the candidates in question. It occurred in what everybody knows as and is referred to as a primary. That's what it was. So I agree that it's not a perfect fit with 13-20, right? But it's close enough. And here's why I'm not particularly troubled by it. Assuming there were no statutes at all, nothing. Title 19 did not exist. And the question is, what's the fairest thing to do? What's the equitable thing to do? All right. Now, you have 74 vacancies. You have 77 people who want to fill those 74 vacancies. Fair enough. All right. It seems to me that the fairest thing to do is to give the top 74 vote getters the job, so to speak. Somebody will finish first, somebody will finish 15th, somebody will finish 74th. The person who finishes 75th, 76th, 77th, they're out of luck. That's not a controversial position. It's true if you treat all 77 as a binary, one or the other, then yeah, that's different. But that was never anybody's intent in terms of voting for the election. That was a result of the bracketing that occurred because of several lawsuits, et cetera, et cetera, et cetera. Again, I'm not going to go into that again. That already occurred, it was litigated, resolved, whatever. So I start with the sense of basic fairness is that you had 3 progressive candidates, and I think the truthful answer always is going to be their best case scenario was that they were going to get 3 seats out of 74. They couldn't expect 4, they couldn't expect 74, right? They ran 3 people. I'm not being critical, right? It's just a fact, all right? The other side ran 74. If it had gone the way that they hoped, all 74 would have been elected. It didn't. So it seems to me that had there not been any bracketing, and I understand it could be write-in votes. Some people think it's funny to write in fictitious names, that type of thing. But I doubt there would have been 3,300 write-in votes. Possible. There's no evidence that there was some write-in candidate in Cherry Hill that, but for the bracketing, would have finished 74th or 10th or whatever it is. The reality that I think everybody in this courtroom knows, I certainly think it, is that but for this bracketing, and Mr. Tambucci argued in his brief that the committee Democrats were placed in Siberia, balanced Siberia, something. It had to do with the placement. But I'll discount that for now. I think because the progressives' victory was very large. I think without the bracketing, the result is the 3 progressives finish 1, 2, and 3. I don't know which is 1, which is 2, which is 3. All right, and then 74 of the 77 finished 4th through 74th, and 3 of the 77 finished 75th, 76th, and 77th. And the net result of all that is you have 77 members of the county committee from Cherry Hill, 3 progressives, and 71 committee Democrat members. That's what would have happened. I'm not going to belabor the point. And that is the equitable result. It's really a simple, by the way, 2-3, 5-2 and 5-3, assuming this case goes to the appellate division, they can read it all they want. I think Mr. Tambucci's argument is a bit stronger for the non-application of those particular statutes when you have a tie vote in a primary. When you have a classic tie vote in a primary, I don't think anybody disagrees that 13-20 applies, right? This was a little bit different, but I think that the result that I'm ordering here comports with the spirit of 13-20, okay? Even though how this vote arrived at a tie was a bit unusual. And that's the bottom line. That really is. Right? So I'm not going to repeat all the, I had a lot of dialogue with Ms. Bromberg that wasn't just done for the purposes of having a colloquy. I think that's the appropriate outlook on this particular case. All right, so I have a proposed order here from Mr. Tambucci. Any objection to the form of the order?
Your Honor.
Sure, take your time. By the way, I'm signing the AG's order in regard to the 113 amicus. That's not going to work.
Your Honor, I'm looking at the order proposed.
All right.
I want to make sure that I'm looking at the right one. This is attached to the brief in support of
Yeah,
the
it's
plaintiff's.
2 pages. Let me go to the most pertinent part. It's on page 2, second to last paragraph. You have it? It is further ordered that the members of the CCDC residing in Cherry Hill are certified by the county clerk by a majority vote shall fill the 71 vacancies, ... All right, that's the order that I'm referring to.
Right.
Any
Yeah.
objection to the form of the order?
Well, Your Honor, with regard to the first paragraph, ordered that the defendants shall be enjoined from conducting meetings, adopting bylaws, or attempting to fill. I think I put on the record that that's extremely vague. And furthermore, the second,
Before you get to the second, let me relook at the first. We're going to relook at the organizational meeting.
mainly they already met, they already had bylaws.
Yeah, but injunctive relief very seldomly is applied retroactively. It applies from the date, the minute that the order is signed. But that, I understand there can be squabbles about what words mean at the margin, and I'm very reluctant to stick my nose into the internal affairs of the Camden County Democratic Committee in terms of who's doing what. But paragraph 1 basically indicates under law what they can't do. In other words, 2 members just can't get up and have an organizational meeting. It doesn't matter, my order, not whether I order it or not, you can't have 2 people just get up and say, we're just going to form our own little club here and promulgate our own bylaws and do our own thing. So the paragraph really doesn't do anything, doesn't really preclude anything that, but for the paragraph, your clients would have been able to do. That's my take on it.
Your Honor, if there is a recognition here that there was already a meeting, there was already an adaptation of bylaws, I think that that would be helpful.
Well, I'll say this, I don't want to put anybody on the spot. I don't have any motion that seeks to hold somebody in contempt for violating a court order. I don't know what tomorrow brings, nobody really does, all right? This particular order takes effect now. Whatever was in the past was in the past, all right? And in terms of paragraph 2, which contains some rather short deadlines, any objection to that, any concerns?
Yes, serious concern, Your Honor.
Yeah.
It provides that it is further ordered that within 1 day of the date of this order, the chairperson of CCDC shall provide notice with regard to the place of meeting to fill the 71 remaining
Right.
vacancies. I would submit, Your Honor, that that should be completely struck in here because we will be taking an emergency appeal of the decision. And for the same reasons that you provided for the OTSC.
I understand what you're getting. I kind of anticipate it. So they're asking for a stay. Basically, they're asking for the same thing that you got a week and a half ago, which is basically to freeze anything. And we'll discuss the time periods. But I wouldn't say it's a courtesy. I would say that under Crow, all right, I basically froze the situation back in late June. The progressives have represented they're going to file an emergent appeal of this, and so I'm not opposed to basically ordering what your order states, but staying paragraph 2 and 3 for a finite amount of time, and then after that, assuming there is a notice of appeal, the appellate division can manage this case. So what's your position on that?
I don't have a position on that, Judge. My position is that we don't believe that any bylaws that were enacted by the 2-3 people are in effect, if that's what they're trying to get at. What we do, we will give courtesy for sure to the other side with regard to their rights to file the appeal and agree to the stay that Your Honor seeks to impose.
All right. Everybody should understand, I'm not going to put a lot of verbiage in the order. I'm not invalidating any of the bylaws or sanctioning anybody's behavior up until now. Tomorrow, if somebody alleges a violation of the court order tomorrow, that will be tomorrow's issue. But all right, so looking at looking at the second paragraph. I'll keep the paragraph in, but I'll put in, let's see, paragraphs, it looks like it's 2 and 3. Paragraphs 2 and 3 are stayed. For how much time are you asking for, Ms. Bromberg?
I think pending resolution of the matter on appeal.
Well, I want to give it, here's an interesting thing about Judge Ecorts. You ever hear of Judge E-Courts? E-Courts is the system we use in New Jersey for filing. I have attempted to have orders filed in E-Courts that do not contain a finite stay. It doesn't indicate a day, a week, a month, a year. And I've been told that E-Courts rejects it. It has to have an actual time period. And I am unable to overrule E-Courts. I have to give it a time. Right? Everybody should understand that once the notice of appeal is filed, this is out of my hands. It goes to the appellate division. They decide, based upon both your applications, to either dissolve the stay, reinstate the stay, increase the stay. So you have 45 days to appeal. I don't imagine it's going to take you 45 days to file the notice of appeal, but I'm envisioning a relatively short period of time. There are multiple interests at stake. Mr. Tembusi mentioned the interests of the organization to freely associate, et cetera, et cetera. There are the interests of your clients. There are the interests of the 71 committee Democrats, et cetera, et cetera, et cetera. My inclination is 20 days kind of sounds reasonable. And thereafter, and I'm hoping if there is a notice of appeal, the notice of appeal is filed within the 20 days, so then it becomes Trenton's issue. Does that 20 days sound reasonable? Have vacation plans coming or something like that?
Well, Your Honor, vacation and court schedules, deadlines, but if there's 45 days to appeal, then I would say at a minimum, we should be given 45 days on the stay. What I'm concerned about is having to come back before Your Honor, or come back to the appellate division in the midst of the summer months, when we all know people have their summer going on.
Well, let me ask Mr. Tippler, what's your position on 45 days?
Judge, I have no objection to it.
That's fine. All right. Paragraph 2 and 3 are stayed for 45 days. All right. What I have is BB make copies for everybody. We're going to upload the original. Anybody else have anything that they'd like to put on the record?
Nothing from the plaintiff, Your Honor.
Very good. I appreciate the briefs. I appreciate the professionalism shown. Maybe would you please give this a copy to anybody that wants it, and make sure Nancy uploads it, hopefully before lunch. All right, very good. Thank you all. Good luck.
Thank you, Your Honor.
Thank you.